And now on live stream.
So, right, yeah, I don't know if it's going to take us back into the same live stream or a new one. No, it's going to be a new one. Okay. Hopefully people will find this. So, welcome again, everyone. My laptop just died, so that's why we're starting a new live stream. For the person who just asked a question, it was a very sensible question. You're going to have to put it back in again because I've now lost everything. And what else have I got to do? I've got to do the same faffing around for a moment. So, I've got no idea what is going on with all of this right now. Okay. So, yeah, again, apologies for that, guys. So I'm hoping whoever asked that question isn't gonna kind of lose it altogether. So yeah, what was I saying? Not legal advice. Ask questions as what if questions. And the first, let me see. I think it was me when I shared the screen that caused the problem. So let's not hope it doesn't do it again. Oh, in fact, I've now okay, I've lost everything. Hold on. Right, we're just going to do it freestyle. Right, this wasn't actually the first question, but we'll do this one first. I think my computer's now trying to uncrash itself from everything. This is like going weird.
It's a sign. You should still be on holiday.
Yeah. So I don't know. Yeah, it was when I shared the screen last time that it all kind of died. Here we go. Okay, so it's now, okay, right. Okay. That's working. That's good. Let's get that up to where it was. Zoom in a little bit. Cool. So this is the first question that's coming through the week. And as I say, I'm hoping that the person we just cut off there is going to get back on there. Yeah, happy New Year, everyone. Yeah, if you've got any regulars out there, just say hello. Nice to see who's about. So, right, can you see that, Karisha?
Yes.
Cool. Okay, so let me just change a few bits here as well, make it a bit easier to see. Oh, never mind. So, right, relief duty accepted, saying a family in priority need is homeless. After 56-day no decision letter sent, chased them for weeks. Finally got a letter saying we aren't homeless because have a suitable accommodation for 6 months when landlord applied to court for possession order. Can they end relief duty and not owe the main housing duty when the eviction process is still going on? So the short answer to this question is no, they can't. Let me just bring up the code of guidance because it's a bit of an interesting issue, this, in that councils across the country get away with breaking the law. And part of the reason I think they do that is because the Homelessness Code of Guidance is a little bit vague. So this is the Homelessness Code of Guidance here, which I'm hoping you can all see. So that, yeah, if you just Google this, it's all like free, whatever. Let me just get rid of this other stuff as well. Hold on. Right, you can close. Right, yeah, cool. So if we go to paragraph 6.35, that one. So here, this is about the kind of stuff around Section 21. It'd be interesting to see how this new legislation that comes in is going to change this. But effectively, what it says is the Secretary of State, so we're looking at this one here. The Secretary of State considers that where an applicant is, A, an assured short-hold tenant who has received a valid notice in accordance with Section 21 of the Housing Act 1988, which I'm assuming applies in this case, because there's no mention that the notice isn't valid. And B, the housing authority is satisfied that their landlord intends to seek possession, and further efforts from the housing authority are to resolve the situation and persuade the landlord to allow the tenant to stay in the property are unlikely to be successful. And C, there will be no defence to an application for a possession order. Then it is unlikely to be reasonable for the applicant to continue to occupy beyond the expiry of the Section 21 notice. So, let me just bring this down slightly. So, I guess by the sounds of it, all of these three criteria apply in this question. So the question then is, okay, when is it likely, or when is it unlikely to be reasonable to continue to occupy beyond the expiry of the Section 21? Now, there are a couple of local government ombudsman decisions on this issue, and in effect, unless there's some other strange special reason saying otherwise, you would be legally homeless once the Section 21 has expired. As I say, if these three criteria apply, in most cases it would apply. As I say, the Code of Guidance is not giving huge amount of detail here, which is unhelpful. But what that means is that essentially the day after the Section 21 notice expires, you should be considered to be homeless. So therefore, that's when the relief duty should kick in. And that is also technically when the interim accommodation duty will also kick in if there is also reason to believe that you might be in priority need and might be eligible for assistance. So that's kind of how this would all work in theory. Let me just change a couple of bits of my display here. So yeah, let's just go back to the question now, just to bring it kind of back to basics here. So yeah, so in this situation, if the eviction process is still continuing, as in still going through the courts, then I can see no situation in which you should not be considered to be actually homeless. So I don't quite understand how the council has kind of thought this would be correct. My guess is it's from lack of staff training more than anything. But basically what that not homeless decision should say, it should basically give an opportunity to challenge it through the review process. So at the end of the letter that says you're not homeless, having given the reasons why they think you're not homeless, you can then basically write to request a review under what's called Section 202 of the Housing Act 1996, which is a fancy way of saying just challenging the decision. And you can basically lay it out. And if it was me, I'd basically quote those paragraphs from the Code of Guidance. In fact, if we just go back there briefly, because it does actually go a bit further, which I'm not quite sure would be relevant in this case. But so that's what 6.35 says. And just a little bit of kind of context on this. This term here, reasonable to continue to occupy, is basically a proxy for being homeless. So if it's not reasonable to continue to occupy accommodation, then you are legally homeless now. You don't have to kind of wait until something else happens. And so if we go to 6.36, the Secretary of State considers that it's highly unlikely to be reasonable for the applicant to continue to occupy beyond the date on which the court has ordered them to leave the property and give possession to the landlord. And 6.37, housing authorities should not consider it reasonable for an applicant to remain in occupation up until the point at which court issues a warrant or writ to enforce order for possession. So that's the fancy way of saying the bailiff's warrant, I believe. So that should never happen, but that's kind of, a lot of councils just do that all the time. They always kind of, regularly they'll say, until the bailiff kind of order has been given, we're not, or even the date that the bailiffs are going to come and evict you, we won't help. And that is definitely unlawful, but it's probably unlawful a long way before that in the Section 21 process. And again, so 6.38, just to kind of underline it all, housing authorities should ensure that homeless families and vulnerable individuals who are owed a Section 188 interim accommodation duty or Section 193 main housing duty are not evicted through the enforcement of an order for possession as a result of a failure by the authority to make suitable accommodation available to them. So this stuff should never happen. But I think because so many councils have got away with it for so long, unless you go to the local government ombudsman and complain, nothing's going to change. And as I say, this is probably something which is, this will change as this new housing legislation comes in with the ending of the Section 21 eviction process, or the changing of it. I'm not quite sure how we're even kind of supposed to talk about it yet. So that's kind of, the answer, as I say, let me get the question up one more time. That's the answer to the question. But I think the way you would practically deal with this is you essentially either make a complaint or you'd request a review of that decision, and you quote those paragraphs. And in most cases, you'd hope that'd be enough, to be honest. Some councils would be very difficult about it. Certainly London councils, you can expect a lot of resistance, but that's the way it should work. So yeah, they can't end the relief duty, because at that point in time, you're still homeless and you're still eligible for assistance, we're assuming. So the two criteria for the relief duty kicking in the first place is the council need to be satisfied that you are in fact homeless and you are in fact eligible for assistance. But if those two criteria are met, then the relief duty is triggered. And if you're owed the main housing duty, which the person says here that they're in priority needs, so we've got a family with children, so they're automatically in priority needs. After that 56-day period has elapsed, the council should be in a decision to issue a Section 184 decision, which will say whether or not the main housing duty is owed, which it probably will be. So I'm going to go back to the Code of Guidance one more time, actually, just to make another point about it. So you'll notice here So where it says 6138, housing authority should ensure that homeless families and vulnerable individuals who are owed Section 108 or Section 193. So it's entirely possible that within the kind of the timeline that the courts are processing the eviction paperwork and so on, that actually the council should have ended the relief duty because the time has expired. And if the household is in priority need, they're homeless, they're eligible, they're not intentionally homeless, and local connections taken care of, then they would at that point be owed Section 193, which is why that's included there. So there's no reason, yeah, as I say, this is why the Code of Guidance is anticipating situations where actually, the timeline would have already expired by the time the actual eviction process gets that far, and you'd be owed the Section 193 duty. So hopefully that's answered the question. Karis, do you want to add anything to that at all?
And
I've just seen
also,
how many. Oh, yeah, go on,
yeah,
sorry.
I was just going to check if you can get a solicitor in your area. They might be able to give you some advice on your specific situation.
I didn't actually ask you before the live stream, Karis, what's Virgo's capacity like at the moment? Is it nightmarish, or is it likely to potentially be a bit more fluid in the next few weeks?
No, it's less fluid still. Yeah.
Okay. So if you just Google Virgo solicitors, you'll get their contact details. They can work with you anywhere in the country, as in England, because of the wonders of Zoom and so on. So yeah, do check them out, because again, I think legally it's quite a straightforward situation where where basically a solicitor getting involved will probably get the council to wake up a little bit quicker and get it sorted out. So that's the first question that came in through the week. I've got to find the other one now because we lost everything. Yeah, welcome to those guys who've just come in. If you're wondering why there's been 2 live streams tonight, it's the first one, my laptop broke and now it's
I've
working
still
again.
got it.
Have you got it? Oh yeah, nice one, thanks. I haven't got it now. Oh yeah, no, I do. Yeah. Here we go. Okay. No,
Is it
yeah,
in
thanks,
the,
Chris. It's actually in the chat, isn't it?
yeah.
Okay, cool. So let's get this one here up again. So it's just this is just a quick question based on the video I posted today about average waiting times. So the question was, are the priorities the same for those with priority needs? This kind of links into the idea that priority needs, when someone says priority needs, I get a little bit suspicious that they're potentially confusing priority need within a homeless application versus kind of priority banding or priority points within the general housing register kind of policy. And so just to make the point that the video I posted today is solely about homeless applicants, as in people who've made a homeless application and have been treated as homeless, rather than people who might be band 1 or band 2 or band 3 or band A or whatever on the housing register generically, because the time limits will be different for reasons I won't go into. So as I say, the figures I posted today are just about homeless applicants. So yeah, I did a video a little while ago, maybe about a month ago, it feels like, where I kind of did basically comparing what the law says about priority need versus medical priority points and so on, because it's important that you understand there's 2 processes which you will probably interact with at some point if you approach a council for help. And it seems like they try to make it as confusing as possible on purpose, because they use the same terminology or nearly the same terminology for both parts. But Part 7 is the one you care about if you're making a homeless application, because Part 7 of the Housing Act 1996 is the one which basically states what the law is about, assessing someone's homeless application. So that's the questions we've added through the week. Let's get back to the comments. How you right, Chief's Face? Nice to have you here. Happy New Year to you too. Okay, so I think the first question I'm seeing there is the question we've actually just answered. That question came in on the channel a little while ago, so I'm assuming that's the one there. So again, if that person wants to add anything to that question or kind of change anything, feel free to. Okay, so just to clarify again, guys, it might seem like I've been really difficult, but I'm just going to ask that you don't ask questions about your own situation explicitly. So ask questions as if they're about someone else. So the question that Dave's asked there is kind of it's kind of good because it doesn't identify who's asking, who's actually in that situation. So if that person who just removed their question, if you could just rephrase it and just put it as a what if question and try and separate out what it is you want to know from a legal point of view versus the kind of the ins and outs of the situation you're in, if that makes sense. So so I'm pretty sure we've answered Dave's questions there. Thanks, Cheeseface. just saying about the kind of this idea of how the data can be used from the video posted earlier. That's exactly how I think, because although a lot of people will want to stay put and potentially they'd rather wait longer in their own area rather than move to another area. I know there will be people who would rather move a little bit or move potentially a lot if it's going to result in a much shorter waiting time, which I guess is kind of what I'm envisaging the data will be used for. And then Cheeseways asking, I feel a follow-up might be in order, though it might just be London councils, but overcoming pushback from housing officers not wanting to take applications on, even though they should. Yeah, I mean, yeah. So it's not just London councils, although they are very adept at kind of various ways of gatekeeping people. But yeah, I've seen councils across the country gatekeep people and deny them the application process. So it's potentially a little bit of a different game. So in London, they know what the game is, and it seems to me as though unless you get a decent solicitor involved in the situation, they just won't budge. Whereas other areas in the country, it can be a little bit more fruitful to actually challenge them yourself without a solicitor. Obviously, a solicitor is going to help in most cases. So, next question that I can see is this one here. So what if caseworker writes in housing plan that they'll put someone on social housing list by 29th of January, but relief duty ended on the 23rd of January or December? I'm not quite sure. I'm guessing January. I'll take it as January. Also, does the housing officer have to stick to housing plans? So good question there. So I'm a OCD here, so I'm going to change the font because that's bothering me. Let's make it all 11. There we go. So a little bit of context for this. Housing plan, or also known as personalised housing plan. Technically, it's actually just called a personal plan, but everyone calls it a personalised housing plan, a PHP. And that is something that should, in theory, be written collaboratively between the homeless applicant and the housing officer. Now, what often happens is the housing officer just gets a template and just writes in any old nonsense that kind of ticks the boxes, and it's not really meaningful at all. But some officers will actually go into a bit more detail. So, yeah, I mean, okay, let me just break this. There's two questions here, I guess. So if you are owed either the relief duty or the prevention duty, so the relief duty is the duty that's owed to you if you are already homeless and you're eligible for assistance, which is basically having recourse to public funds. And the prevention duty is basically there where if you're likely to become homeless within the next 56 days, then that's when the prevention duty kicks in. And again, it gives the council time to actually try and prevent you becoming homeless in the first place. But for either of those two categories of people, so if you're owed either the prevention duty or the relief duty, you get something called reasonable preference. And that term reasonable preference means that the council have to put you on the housing register. It might be the lowest band, often it will be the lowest band, but they have to put you on the housing register. So the idea that they will only put you on the housing register once the relief duties ended is not lawful. What will probably happen is at the end of the relief duty, if you are in fact owed the main housing duty, so if you are in fact priority need, you are in fact not intentionally homeless, and so on, then often the banding will increase. But someone who is under the relief duty should be on the housing register already, and they're provided you provided all the kind of paperwork and the documents and stuff that you need to do that. But the council can't just kind of say, well, we're not going to put you on the housing register until you're until the relief duty is finished. And I'm going to again just take me to the social housing list to mean the housing register. So yeah, that's not I mean that doesn't sound lawful to me. What you might want to do before you make a complaint about it is go on the council's website and search for the term housing allocation scheme, because the housing allocation scheme is basically the fancy term for the policy that governs social housing. So it's the policy for the social housing list, so to speak. And they have to publish it, they have to make it available to everyone. And in that policy, let me just I'll show you Bedford's just to show you an example. So let me just get up. So if I just search for Bedford Borough Council Housing Allocation Scheme, you can do this for anywhere in the country. So let me just share the screen so you can see what I'm looking at. This one here, I think. Cool. Karis, can you see the movements? Yeah, you see that one there? Yeah. So if we just go back up to the top, so this is, I mean, every area is different, which is why this is very complicated to explain to a kind of English audience, because Every council has a slightly different policy, or sometimes a very different policy. But if we just search for the term relief duty, so here it says on page 27, so this is what it looks like is about 60 pages long. To meet the requirements of the Housing Act 1996 and changes brought in by the Homelessness Reduction Act 2017, reasonable preference will be given to applicants who have a statutory entitlement and or are owed a main prevention or relief of homelessness duty. So it's a rather wordy way of saying if you're owed either the relief duty or the prevention duty, you have to be on the register as well as those with the main duty. Now, if we go through the banding for Bedford, and again, just bear in mind, this will be different in every area. Every area will have a different banding system. So, in fact, it doesn't actually go into enough detail there. So band E is for emergency. Bedford, again, everywhere's different. Band A. But if we go down a little bit, in fact, if I just go to the next entry. So, yeah, so in Bedford, you get band C if you are owed either the relief or prevention duty. So you get band C, but then if you're owed the main housing duty, which is at the end of that end of the relief duty, they make a decision. You then would get the homeless duty acceptors. That's basically talking about the main homeless duty. So you get band B. So that's how it works in Bedford. So if you're under relief or prevention duty, you get band C. And then once the decision's been made that you are in fact owed the main housing duty, then you go up to band B. And in Bedford, yeah, you need to be band B really to get a chance of being housed. But it does vary around the country. So we've talked before about Buckinghamshire's policy, which basically gives the lowest band to people owed the prevention or relief duty. They give band E, and then it only goes up to band D if you're owed the main housing duty. But that's kind of an example of of many that I mean, I could just kind of do a few more policies, but I think that should give you the idea of what goes on. So so that's a long way of saying it, but that's just basically saying why the housing officer is not correct to say that you don't get on the housing register until after the relief duty. You should be on the housing register already. So that's the first part of the question. And then the second part, does the housing officer have to stick to the housing plan? Yes, they do. But I guess it depends exactly what it is they've said they're going to do. If they've said they're going to do something which is quite, trivial, that's not going to make a meaningful difference to you, then if they don't do it, then, okay, never mind. But if they've said that they're going to, for example, put you onto the housing register and process your application, but they haven't, then that would be reason to complain. It'd be reason to complain anyway. But if they said they're going to do it in the personalised housing plan and they don't do it, then you've kind of got more evidence that they haven't done what they said they do. Same would go in most cases for homeless applicants need to do what's in the plan, but there are varying kind of penalties for not following through with the plan. I have seen councils say that people who don't actively go and look for their own private rented accommodation are not cooperating, which kind of like affects how much help the council will give you. But yeah, hopefully that's answered that question. So yeah, and again, just for that, again, sorry to be difficult. The person just asked some more questions. It's in the first person. Please, can you just rephrase it as a what if question? So I see what you're saying, but I just need to kind of make sure people are keeping their data previously correct, kind of how it should be. So I'm just going to change this slightly. So again, same issue here, but you just notice how I'm changing the question from the so if I just do that, yeah, you can see how I've just anonymized that question. And again, I'm just going to delete it. So just it's off the live stream chat, but you can kind of see the question that's been asked. So good question about local connection. Probably best way to answer this is again just to go back to the Homelessness Code of Guidance. So I haven't actually said this yet. The Homelessness Code of Guidance is a PDF. You can Google it. It is the rule book that councils have to follow. And if we go to 10.6, I think, no, 10.9. Because this is so chapter 10 is all about local connection. So 10.9 for the purposes of C, which if we go back up, let's explain what this is saying here. So 10.4 gives the part 7 definition of local connection. Bearing in mind that part 6 we use a different definition, which is super confusing. But you have local connection when you make a homeless application if any of these 4 things apply. So you've lived somewhere for the last 6 months or 6 out of the last 12 months or 3 out of the last 5 years. You're employed there. You've got family associations or other special circumstances apply. So if we then go to 10.9, when it says C, it's referring back to that paragraph 10.4. So for the purposes of C, family connection, where the applicant raises family associations, this may extend beyond partners, parents, adult children, or siblings. They may include associations with other family members, such as step-parents, grandparents, grandchildren, aunts, or uncles, provided there are sufficiently close links in the form of frequent contact, commitment, or dependency. Family association should be determined with regard to fact-specific circumstance of the individual case. For example, the actual closeness of the family association may count for more than the degree of blood relation. A housing authority should not identify local connections through family associations with an area other than the one where the applicant positively wants to live, which is a really interesting last sentence to it as well. So that's kind of hopefully answers that question. So it's going to be, the key thing here is going to be this bit here. So, you know, what evidence is there of kind of frequent contact and so on? That might be, you know, letter from the aunt or uncle potentially. Sometimes you won't always have proof, but I'm not quite sure to what degree councils would need evidence from you. The default position would be to believe you unless, you know, they've got reason to think otherwise. So, yeah, that hopefully answers that question fairly succinctly. Again, Karis, if you've got anything to add or correct me on, feel free. But yeah, so let's expand this slightly. So what can often happen, and this is really important to understand. In fact, let's just go into this. I'm just going to search for West Sussex's housing allocation scheme. West, I've got Sussex. Where's West Sussex? Why is West here? No. Right, hold on a sec. I need to figure out my geography slightly. So my question actually is West Sussex a kind of a separate thing, or is it part of? So what? Yeah, okay. So looking at the map here, so West Sussex is a kind of a combination of different councils. Let me just show you what I'm looking at right now. So yeah, so West Sussex is kind of this area here, which includes Chichester, Arran, Worthing, Ida, and Mid Sussex, and so on. So let's just do it for Mid Sussex because that one just came up a minute ago. Let me just find it again. So in fact, let's look at Chichester because it's literally the one in front of me. So if we look at Chichester, if the person in the chat just wants to kind of clarify which sub-district it is, but so here's the allocation scheme for them. So if we go to local connection, if we search for that term in this policy, you'll see how it's different. So there's 18 hits, and I just need to find the one which actually defines local connection. What does that say there? A detailed description of the way local connection is defined is shown in Appendix 3. So let's go down to Appendix 3. So here's Appendix 3, which is the definition of local connection. But this is the important thing to understand here. Chichester's definition of local connection is specific to Chichester under the normal policy. But the bit I just showed you from the Homelessness Code of Guidance is the definition if you're making a homeless application. So if you are homeless and you approach Chichester Council, they should use the Part 7 definition of local connection to assess your local connection. What can often happen is the housing officers you actually deal with don't know the first thing about the differences here, and they will apply a much stricter criteria. So if we just look what the criteria is here. So for example, if you're going to try and get local connection to Chichester through residence, you need to have lived there for the preceding 2 years without a break. Now compare that to the Part 7 definition, which was either 6 out of the last 12 months or 3 out of the last 5 years. You'll notice that this definition is stricter, or 4 out of the last 6 years. So again, it's kind of stricter than the Part 7 definition. You'll also notice here that to get local connection through employment, and this is fairly typical of most councils, it specifies that you need to work there for at least 16 hours a week, whereas under Part 7, under the homelessness definition of local connection, there's no minimum number of hours you need to work. And then here we've got this idea, which again, so need to move to the district in order to provide or receive care for a close family member who might otherwise not be able to remain living independently. Now that's a lot stricter than the Part 7 definition. So what often happens is you apply to, you walk into Chichester Council, let's say, and say, look, I need to get help with housing. They incorrectly miss the fact that you're actually homeless and therefore should be dealt with as a homeless person, and they'll apply this much stricter definition of local connection on you rather than the very, the rather kind of relaxed Part 7 definition. So yeah, I think that's probably what might have happened. It happens quite a lot. So someone approaches the council like Chichester and says, here's my situation. Can you help me out with housing? And they essentially say, well, you don't meet any of those criteria. So the answer is no, you don't have local connection. Whereas if you dealt with properly as a homeless person, it's not even kind of dealt with until further down the line in the process. So, Karis, did what I just say make sense? Yeah, because it is ridiculously confusing. There's no kind of getting around that. So okay, so it's Crawley. So do you know what? Since we're kind of this is a useful thing to understand. Let's go check out Crawley's housing allocation scheme. And again, I can't spell anything when I'm trying to do two things. So Crawley Housing Register. Let's have a look here. So again, they're not okay. So they're not housing. Yeah, so it's a little bit hidden. That's not good practice. So you should be able to find the policy very quickly. But here's the Crawley policy. So we'll look through it again. So again, I'm going to search for local connection. And again, so they've got the definition here. So applicants who fulfill any of the following categories will be assessed as meeting the local connection and residency criteria. So in Crawley, you need to have lived continuously without a break for 5 years. So, Chichester was, whatever it was, 2 years. Crawley, it's 5 years. So again, it might well be that, you have a lot of people who will meet the criteria under Part 7, as in 6 out of the last 12 months or 3 out of the last 5 years. But if they apply the wrong definition to you, then they're going to incorrectly say that you can't join the register. And again, applicants with an immediate family member. So that specifies immediate family members, whereas Part 7 specified it could be kind of wider family or more extended family. And they have to have lived there for at least 5 years or more. So, and here, to get connection through employment, you need to have been employed permanently for the last 5 years, which again is not something which you see in Part 7. So let's kind of stay on this for a minute. And again, I'm talking very fast and hope this is making sense. If we go back to the Homelessness Code of Guidance, there's an absolutely crucial, so 18.6 is absolutely crucial because essentially what it says is, so this chapter 18 is all about making homeless applications to a council. And I'll read 18.5 out as well because it's probably the most important paragraph in the whole guidance. So 18.5, homeless applications can be made to any department of the local authority and expressed in any particular form. They need not be expressed as explicitly seeking assistance under Part 7, as long as the communication seeks accommodation or assistance in obtaining accommodation and includes details that give the housing authority reason to believe that they might be homeless or threatened with homelessness. This will constitute an application. So to make a homeless application, you need to approach any department of local authority, and you need to tell, and you basically, let me rephrase that. You need to ask any department of local authority for help with housing, and you need to give them reasons to believe that you might be homeless. Very low threshold. That's what triggers a homeless application. Now, 18.6 makes the point. Housing authorities should take particular attention to identify instances where information on an inquiry about a social housing allocation scheme or an application for an allocation of housing under Part 6, so that's basically applying to the housing register, provides reason to believe the applicant might be homeless or threatened with homelessness. This should be regarded as an application for homelessness assistance. So I could talk about this all day because it affects so many different people. But basically, if you fill in, if you go on the council's website and say, I'm homeless, it will direct you often to the Part 6 application form. So you fill it in, you don't know what it is, fill it in, you don't know what the law is, understandably. And they don't pick up on the fact that you've actually told them that you're homeless, or you might be homeless, or you might be threatened with homelessness, and therefore they incorrectly apply these much stricter Part 6 definition of local connection on you rather than Part 7. So I have not found a way yet of explaining that any better than how I've just explained it. So I'm hoping that makes sense. But that's kind of, I think, what we're probably talking about here is we're talking about someone who might be homeless or threatened with homelessness. They've gone to a council, any department, they've done it in some way, and the council said, you don't meet our Part 6 definition of local connection, but they should have actually done it as Part 7, and therefore it's much more relaxed. And it's actually possible to get local connection under Part 7 if you've got no local connection anywhere. But anyway, so yeah. hopefully that has answered that question. Karis, anything to add to that?
No, that was really good.
Yeah, hopefully people followed it vaguely. Yeah, I've done a few videos on the channel about that and go into more detail, but even then I've still not done I don't feel like I've done a very good job of actually explaining how it works. So let's get back to the questions then. So yeah, good question, by the way. Right, so okay, I think this is the next one here. What if someone is staying at a friend's home while in relief duty but will check themselves into hotel to stay in the area? Will they be given the local housing allowance for a 1 bed or 2 bed rate, 1 adult, 2 kids on universal credit? So I have to confess, I wish Shannon was here because she would know the answer better than I do. It certainly used to be able to claim, bearing in mind I've kind of not dealt with the situation since housing benefit was around. You used to be able to claim housing benefit for hotel accommodation. It would often be much less than what the hotel would actually charge you, but it was something. So I remember a guy back in the day, like in the sort of noughties where I worked in the night shelter, he would do that. He would basically travel around different hotels and claim housing benefit. He wouldn't get the full amount back, but he would get some of it back, and that enabled him to kind of long out how long he could stay in hotels for. So I think the answer is yes, but don't quote me on it. The best way to find out for sure would be to contact the council's housing benefit department. Sorry, no, contact Universal Credit and just basically ask the question there. So I don't know the answer. I don't know, Karis, do you know the answer to this one for sure?
Yeah, I'd have to say
No.
no.
I mean, so it might be if I remember, I'll roll that question on to next time. But I think, yeah, as I say, if you contact your Universal Credit on the kind of usual system, I would hope that they'd explain that to you. I think even a Google search might probably do a better job than I just explained it. But yeah, there's some. Yeah, if I remember, I'll kind of raise that question and come back with a better answer next week.
This is also something the housing officer should be helping with. And why are you putting yourself in a hotel to stay in the area? Have they offered them something? Yeah.
This is very true. Yeah, so what we're talking about here about someone who is who's
Under the
going to be
nicotine.
yeah they're going to be in they're going to be in priority need if they've got two dependent children, which I'm
Yeah.
assuming is the case here. So yeah, so I think it would go back to getting everything in writing and kind of just making sure you're emailing the council these questions. Basically, email them and say, look, I'm homeless. I've got 2 kids. I'm currently staying with with a friend. Can you not help me out better? Can you not provide temporary accommodation? Put it in an email wherever you can. Basically, don't ever speak to a council over the phone because this is all a legal process. Anything you say can be used against you in effect. So you want to basically make sure that you have kind of you've got backup and you've got records of what's been said, what's not been said. Okay, so yeah, good question here. So, right, this might even be worth me doing a standalone video on. So, if you live in London and are homeless with kids, by law, can you email Chichester Council and start an application? If not, how can people move around the country as in your last vid? So, the answer is yes, you can. So, if you can, when you're homeless, you can apply to any council in the country, and you should do that by email. That's the way to do it. And the initial duty to you, so the duty to take an application, the duty to accept a relief duty, and the duty to provide interim accommodation applies to anyone who approaches them. So again, I'm going to go back to the code of guidance because it says it better than I can. So if we go to a 15.4, so this is section 108 is the duty to provide interim accommodation. Sometimes people call it the emergency accommodation duty. So 15.4, Section 108 requires housing authorities to secure that accommodation is available for the applicant and the household if they have reason to believe the applicant may be homeless, may be eligible for assistance, and may have a priority need. So you'll notice that this does not mention local connection or intentional homelessness because those are not relevant at the initial stages. So if you're from London and you approach and you basically emailed Chichester Council and said, look, I'm homeless, can you help me out? I've got kids, I'm in priority, I'm eligible for assistance. Then Chichester Council would have a duty to provide interim accommodation. Once they put you in interim accommodation, they'll very quickly start the relief duty, which happens when they are satisfied that you are in fact homeless and you are in fact eligible for assistance. They only then can they start looking at local connection. And let's say you apply, basically, they carried out the assessment, the Section 189A assessment is called, and they established that you don't actually have a connection to Chichester, but you did in fact have a local connection to a council in London, then they should legally continue to house you in Chichester in interim accommodation, contact the London Council and make a formal referral back to that London Council. So going back to the video about what I'm talking about when you can use that data, there are going to be people who are fleeing an area because of abuse. If you were fleeing abuse from London and you went to Chichester, Chichester cannot refer you back to London if there was any risk to you in that district. It would also, the data could also be used where you've got more than one local authority, local connection. So let's say you've got a local connection to, I don't know, Newham, and you've also got an aunt who lives in Chichester who you kind of see regularly and all the rest of it. Then you would have a connection in both areas, so you could approach either area. And again, the reason I put that data out there is that the waiting time in Newham is like 10 years for a 2-bed or whatever it was. I can't remember the exact details, but in Chichester it's going to be a lot less than that. So in that situation, again, you might use that data to say, well, do you know what? I don't really mind which area I live in, but I know that in Chichester the waiting time is much less. Therefore, I'm going to apply to Chichester rather than Newham or whatever, Camden or whatever. So hopefully that answers that question. So yeah, so in one sense, for those who have got a local connection and it's safe to be in that area, although you legally can approach any council in the country, there's no real point because you're only going to get referred back to your home area. But as I say, in the situation where you're fleeing abuse or you've got multiple local connections, because it's not unusual to have multiple local connections because you might have families dotted around and job in one area and whatever, living in another area, then you are able to approach more than one local. Yeah, it's pragmatic to approach more than one area, or pragmatically you can approach more than one area depending on your preference. So yeah, that's kind of what I'm talking about with that data. So next one, just to reiterate, I'm not going to answer questions that are in the first person. Okay, so then I think this is a follow up to the that previous question. Let me just double check that. Yeah. So yeah, so I think this is kind of follows up the question that Karis kind of wanted clarification on. So the council offered to house them outside the area, so we'll stay with them until the end of the month and then stay in a hotel. So my guess here is that I'm sorry, I put it in the wrong bit. Put it back on question 5. So my guess here is that you've approached one council, they've then said, yeah, okay, we're going to house you 200 miles away. And you've said, well, do you know what? I've got reason not to go 200 miles away, so I'm going to stay put at a friend's thing. Now, the location of accommodation, any accommodation the council offers you, they have to assess your situation very carefully. And so if they're going to house you, too far away, particularly if it's interim accommodation, they should be taking into account the kids' schools. And again, if you search for school transport guidance, it states that essentially states that kids should not be placed more than 45 minutes away door to door if they're in primary school age, primary school, and 75 minutes or an hour and 15 if they're in secondary school. So there's a really good case, which top of my head is called YR Lambeth. So if you search for the letters YR space V space Lambeth, there's a really good case from a couple of years ago which basically specified that for a council to house you a long way away, they need to go through a lot of different steps to show how they've assessed that as being suitable. So you might, in this situation, be able to challenge the council's, essentially their offer of accommodation to say it's not suitable and therefore reinstate the duty for them to provide interim accommodation more, kind of more close by. So that's kind of potentially, and again, in the real world, you probably need a solicitor to kind of do that because it's quite a complicated argument to make as a lay person. It's kind of a solicitor is fairly straightforward because they're just familiar with the process and so on. So I would say potentially you might want to pursue yeah, kind of getting a solicitor in that situation and just kind of going back to the council and saying, actually, that offer of accommodation hundreds of miles away was not okay, and therefore you haven't actually discharged your duties properly. So that is all the questions I can see that have been anonymised. I'll give you a couple more minutes to put any final questions in. But yeah, other than that, I'm hoping that all made sense. As I say, it feels like there needs to be a standalone video about the differences between part 6, which is those kind of, the different housing allocation policies, and part 7, because as we just saw with Chichester's and with Crawley's, the part 6 definition of local connection is much, much stricter than part 7. And so lots of people end up getting told that they can't apply for housing somewhere because they don't meet the part 6 definition, where actually they are a homeless family or a homeless person, and therefore in effect the part 6 definition does not apply to them. It's the part 7 definition which applies, which is much easier to kind of get. So yeah, Karis, any final thoughts? If not, we're going to be back on Karis, you can be back on Monday for Will's one.
Yeah.
Yeah, cool. So I should be on Will's one as well. So Will's going to have his live stream at 7:30 on Monday on his channel. Yeah, so the question just coming. Can you look through Hillingdon housing allocation for homeless and domestic abuse? So I can, but could you just specify exactly what it is you want to know? I mean, I'll start the process. I'll have a look at Hillingdon's policy now, but in one sense, there should be quite a lot about domestic abuse within their policy. So I'm just I mean, there's a lag here, by the way. So if you're thinking we're ignoring you, it's because there's like a 45-second lag between us talking and you actually hearing us. But I'm just going to bring up the policy just to see what it's saying. So it's actually PDF, which I prefer. But, yeah, so let's just get the.
And then you can check out the Homeless Code of Guidance for domestic violence as well.
Yeah, yeah. So yeah, depending on what the question is, here's Hillingdon's housing allocation scheme. And we'll just search for the term domestic abuse now to see what it says. But bearing in mind, this is where it gets really interesting. So if you're at risk of domestic abuse, really you should automatically be dealt with as a homeless person, with a couple of weird exceptions to it. And so actually a lot of the stuff you see within housing allocation schemes don't really make sense legally. So for example, Bedford's an example. So we looked at Bedford briefly, and that gives you like band E, which is like emergency band if you're subject to very severe domestic abuse. But if you're subject to very severe domestic abuse, you should be dealt with as a homeless person and therefore kind of go through a different route anyway. But yeah, let me see if there's been any clarification about that. Yeah, so and just someone's asked about follow-up question about the local connection. So I have got there's a video I did do on the channel not too long ago. I'll see if I can dig it out whilst we're just waiting for clarification about Hillingdon's question, which was about local connection somewhere. Let me just have a little look through. Oh, it might have been a while ago. I can't remember now. Hold on a sec. I'm just going to search it. Right. Yeah. So okay. So it's from the 3rd of May, but I'll just get the link for it. So the title of the video is "Why is local connection so confusing?" Which probably quite an apt title. So here we go. So if I just stick it into the live stream here. So yeah, just so question about local connection. There's the video which I'd suggest you look at. It's got kind of go through what everything in a bit more detail. And so just clarification about the domestic abuse in Hillingdon. So main housing duty, what ban will it be? So as I say, let's have a look through the policy. But I don't. It often doesn't make sense legally in these kind of things. So if I just go through, it's just. So this is the band here. So okay, so let's go back up to the top of it. As you can see, they tend to be quite. So you got reasonable preference groups. Okay, what is it? I'm just going to see if there's a banding thing in particular. So that would make it much easier. Right. the following priority banning will be considered. So, uh, I might not be able to piece this together without looking at it in a bit more detail. It seems to be defining domestic abuse and then kind of as one thing and then kind of taking that further. So, okay, so yeah, this is okay. This is where it's so weird. So, those who are homeless within the meaning of Part 7, let's just go back to the title here. So, Band B, let's have a look if it turns up in Band A or whatever it's called, additional priority. Doesn't look like it. So, looks like if you're in Hillingdon, domestic abuse won't get you Band A unless one of these other kind of situations apply. So, it's then in Band B. Why has it got different? So, case type, defining features of applicant. Okay. So if you are homeless in Hillingdon, you've made a homeless application and you are basically, I guess, you need rehousing as a result of domestic abuse, you get Band B. Let's see if it crops up again. I mean, yeah, I think that might just be as much detail as it goes into. Yeah, I can't see the term cropping up again. So I think in answer to your question, um, you get Band B. However, and it appears you get like an additional priority as well. Not quite sure how that works in practice. Um, So what I'm trying to work out is where do people who are homeless like here but aren't at risk of domestic abuse, what band they get? I can't actually see it. Yeah, I might not be able to answer that question. Oh yeah, here we go. So okay. So I'm just skimming this, guys. If I've misinterpreted this, you have to go and check this out yourself. But basically, so it looks like if you are homeless, owed a duty under Part 7, then you would get Band C unless domestic abuse applies, in which case you get Band D. That's how I seem to be reading that. So I think that hopefully that answers the questions. This is for England, just that question that's come in the chat. Yeah, so this is not, as far as I know, there is no kind of housing legislation like this in the US, and it's different in Wales and Scotland as well, although it's fairly similar in Wales from England. So yeah, so I think hopefully that answers that question of what band would you get in Hillingdon if you are homeless because of domestic abuse. I think that's hopefully answered that question. And then there's just another question here which we'll get into. So Karis, if you need to head off, feel free. We've got to pretty much 8:30. But yeah, so and then right, let me just go back a step as well. So just to make sense, because there's actually, yeah, just for people watching it afterwards. So question 7 was about domestic abuse in Hillingdon. Question 8, there are 3 rules concerning overcrowding, but when I read the code of guidance, I can only see 2 rules. Could you please clarify? So I guess my question from that is, when you say there are 3 rules, where did you get that from? Because I'm not quite sure. Like there's two like definitions of overcrowding, as in it's like there's the space standard and the room standard, which again you can Google if you figure it out. But so I don't know what the third rule would be. But it's actually a little bit irrelevant in terms of the definition of homelessness, because just because you're legally overcrowded according to the definition, the 2 definitions, that does not automatically mean you're in priority need. So again, if we go back to the code of guidance briefly, it specifies that. Oh, where's my? Hold on a minute. No, I can't find the homelessness code of guidance. Here we go. So if we just search for the term overcrowding in the homelessness code of guidance, it probably says something like you're only homeless if it's unreasonable to continue to occupy. So no, I don't want the AI. Yeah. So I don't want that. I want to go back to, it's going to be in chapter 6, if anywhere, or maybe it's not. Is it all in? Okay, okay. It all seems to be in chapter 17, which is about suitability of accommodation. I thought there was something about it in chapter 6 as well. I'm actually going to go back there because I can't believe it's not in chapter 6. Here we go. Yeah, it is. Yeah. So okay. It mentions it in passing there. That's not actually what we're really talking about in chapter 6. Yeah, so really, so okay, so basically, it doesn't even say it's explicitly here, but whether you're homeless because of overcrowding is going to basically come under here. So the question is not just whether you're overcrowded; it's whether it's reasonable to continue to occupy your overcrowded accommodation. And there's no kind of like hard and fast rule. What it then says down here, which is what we saw here, so councils can legitimately look at the general housing circumstances of the district. So if you look at, Tower Hamlets Council, for example, there's a much higher rate of overcrowding in Tower Hamlets than there would be in, let's say, Bassetlaw or some leafy place. So, in effect, Tower Hamlets would be able to essentially require you to be even more overcrowded than the average in Tower Hamlets as opposed to the average in Bassetlaw. So it's kind of taken on a local kind of picture of or a local scene of overcrowding. Oh yeah, sorry, I've just missed a question as well, so I kind of come back. Yeah, come back. Sorry, we'll do that in a minute. But yeah, I think that's yeah. So that's all I've got to say about overcrowding at the moment. I'm not quite sure what the third rule is. And then if we go back to this question, which I just missed, can you? No, not that one. Hold on, let's try that again. So what if the local housing authority stop eviction proceeding? Would they still owe you a duty? What should you do if they're refusing the duty? So the local housing authority could not stop an eviction. I mean, it would be the courts that stop the eviction proceeding, assuming that it's. I guess what the question is, what do you mean by stopping the eviction proceeding? If your landlord serves you a Section 21 notice and then the council go and essentially negotiate with the landlord to keep you for longer, that's often, some councils pay landlords money to keep you longer. That's kind of how they, quite a lot of money sometimes. So it's not that the local housing authorities stopped the eviction as such. They've just basically convinced the landlord or persuaded the landlord to let the landlord themselves to stop it. In which case, you would not be threatened with homelessness anymore, or you wouldn't be homeless because the landlord has essentially taken the notice back and is kind of rescinded the notice. So, in that sense, they're not technically refusing the duty. I think that's what we're talking about here. That's my guess of how certainly how I'm reading this question. So they haven't. It's not the council that stopped the eviction process. It's the landlord has been convinced by the council to stop it themselves, which is a different issue. And if that's the case, and that actually goes back to if we go back to 6.35, sorry for dotting around so much, but I think it's just useful to see it from the code of guidance whenever we can. So if we just go down to 6.35, you'll notice that in effect, councils are expected to try and do that sort of thing. So if you go to a council with a Section 21 notice and it's valid, assuming it is valid, probably will be, then they are expected to make effort to resolve the situation and persuade the landlord to allow the tenant to remain in the property. So that's what they should be doing. And if that's not likely to be successful, that's when this kind of that's when you would potentially be homeless once the Section 21 notice is expired. So that's kind of part and parcel of what the prevention duty is supposed to be about. That I think is what that's what your question relates to. Karis, would you read that any differently or kind of have anything else to say about that one?
No, saying that they're trying to get them to talk to the local authority
Yeah.
on behalf
And
of the landlord.
there's one further question from a name which I can't pronounce because it's in a different alphabet. Just for that person, so that I'm afraid I deleted your questions because they're all in the first person. They're all about yourself. So if you just look back, you'll see I've removed the question, which is what I said at the beginning in terms of asking questions as what if questions. So apologies for that. If you want to put your question into a comment on any video on the channel, I should be able to get it. But again, don't make it about yourself. Kind of make it hypothetical. It's not just data protection stuff that I'm worried about, although I am worried about that. It is about getting people to be able to articulate what the legal issue is rather than everything else. Because obviously, when you're homeless, there's a million things you've got to worry about. We're only able to help with the kind of bits and pieces of what the law says. And so, by getting people to ask it as what if questions, I'm hoping that it will kind of help you kind of work out what is the thing you actually need to kind of sorting out. There's other stuff in there as well, but that's probably all I'll say at the moment. So I'm just checking one final check to say I missed anything. Yeah. So that's it, guys. Yeah. Sorry for the technical issues at the beginning of the night. Hopefully it's got resolved and you found it all right. And I'm hoping that person that put the question on the other video has kind of found us here. But other than that, yeah, hope this is helpful. We'll be back, as I say, on Monday on Will's channel. So if you haven't already subscribed to Will's channel, if you just search for Will Flack Law, I just get double check that. But if you search for Will Flack Law on YouTube, you should find his channel very quickly. We do a live stream there every Monday. And again, we might go off on a tangent in that one. Will tends to talk about some more technical stuff, but we can ask questions like we do in this live stream. So yeah. So yeah, just okay, clarification on this one. So local housing authorities stop their own court proceedings. If they are the landlord, if it's council housing,
Yeah.
then again they can do that. That's kind of that's within their power to do that. So again, that would mean you're no longer homeless if they have stopped it. I'm going to add that caveat to the question just so it makes sense for people. So yeah, hold on. I'm having trouble actually copying and pasting stuff right now. Yeah. So thanks guys. We'll be back here next week, hopefully with a full contingent, so we're going to be a bit more helpful on different questions. Thanks, Karis. Appreciate your time tonight, and we may well see you guys or this coming Monday on Will's channel. So do check it out. Other than that, take it easy, and as I say, hopefully this stuff has been useful.